Good afternoon, everyone. Welcome to the Medical Board of California Panel A meeting. Today is February 12th, 2025, and we're starting at about 2:03 to open up our open session, and we will start with our call to order and roll call.
Thank you, Dr. Bolat. Dr. Bolat?
Here.
Dr. Helser?
Here.
Ms. Mitchell?
Here.
Ms. Torres?
Present.
Dr. Tsai?
Here.
Mr. Watkins?
Present.
We have a quorum.
Thank you. And I want to thank all of us here for being in person. It really is a pleasure to see everyone. And thank you, Your Honor. I will turn it over to you.
Thank you very much, Dr. Bolat. Can the court reporter hear me clearly?
Can, Your Honor. Thank you.
Thank you very much. And we're going to go on the record straight away. Thank you. All right. We are on the record before the Medical Board of California, Panel A, Department of Consumer Affairs, State of California. We're here in the matter of the petition for penalty relief by Arfa Babaknia. That's spelled A-R-F-A, Babaknia, B-A-B-A-K-N-I-A, M.D., Medical Board of California, case number 800-2021-083053. And the OAH case number is 2025-010-382. Today is February 12th, 2025 at 2:04 p.m. currently. Matter is noticed for hearing at 2 p.m. This is the date and time set for oral argument in the notice of hearing for oral argument after non-adoption of a proposed decision. We are conducting the oral argument in person and by WebEx video conference. My name is Wim van Rooyen, spelled W-I-M-V-A-N-R-O-O-Y-E-N. I'm an administrative law judge with the Office of Administrative Hearings that's been assigned to preside over the oral argument today. Just before we went on the record, we had a roll call, and I'm pleased to announce that not only do we have a quorum of the panel, but we have all panel members present today. With that said, can I please have appearances from counsel, starting with the Attorney General?
Yes, Your Honor. Sarah Jacobs, Deputy Attorney General.
Good afternoon, Ms. Jacobs. And then for the respondent.
Marshall Shepherdson of R.J. Ryan Law.
Good afternoon, Mr. Shepherdson, as well. Thank you so much. And then it's my understanding your client is not present today. Is that correct?
Correct.
All right. Thank you so much. For the oral argument, the following process and time limitations will apply. These were also outlined in the order you previously received. First, the respondent will have 15 minutes to make an opening argument. After that, the Attorney General will have 15 minutes for her opening argument. Then the respondent will again have 5 minutes for a closing argument, and the Attorney General 5 minutes for closing. These time limits will be strictly enforced. I will be using my phone to time, and I'll try and give you a courtesy warning at 1 minute before each expiration. But again, ultimately, it's your obligation to make sure you stick to the time. The argument shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. Either I or any panel member may ask a party to support the party's oral argument on a matter with a specific citation to the record. At the end of the oral argument by counsel, normally I would say I would offer the respondent physician an opportunity to address the panel, but since he's not present here, as I indicated to you off the record earlier on, if the panel members have any questions for you as his counsel, I will invite them to ask questions at that time if you are able to answer. We do have a court reporter present virtually to record the proceedings. So to make sure we keep his job easy, we want to make sure we speak loudly and clearly and speak slowly and try and avoid speaking over each other. After oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will be receiving it in the mail sometime in the future. Again, please just remember that all the arguments must be based on the existing record and no new evidence will be heard. And I'm just as a reminder that the board has already had the benefit of reading any briefs or submissions you've submitted beforehand. So with that said, any questions or any matters to state for the record from the Attorney General?
No, Your Honor.
And what about the respondent?
None, Your Honor.
Thank you very much. Then we'll go straight to the oral argument. And Mr. Shepherdson, you will go first, and your 15 minutes starts now.
Thank you, Judge Van Royen and the members of the panel for the opportunity to speak on behalf of Dr. Babaknia. I really appreciate, and I wouldn't flatter myself to think that our cause is why there's a full panel today, but I imagine there are other important matters that the panel is going to cover after this hearing, but I do appreciate the opportunity to speak with you all. I do not intend to take the entire 15-minute allotment, which I hope is good news. I only want to touch on just two main points that I don't feel were necessarily stressed in the briefing and might be helpful for full context before a final decision is rendered. The first point is just a very practical consideration that might not have it wasn't even what the Judge Belvedere relied on in her recommendation, but I think that it's important, if not compelling, is the relatively modest and moderate, almost humble nature of the relief that is being requested by the petitioner at this point. At the time that the hearing took place in September of 2024, the probate period had already gone 7 of 9 years, a full 9 years had passed. And now almost a half a year has passed since that time. So by the time a final ruling is rendered, it will, in all likelihood, be barely more than a year that is going to be shaved off of the probationary period if the relief is granted. And I think that does weigh in favor of granting the petition in light of the length of the probationary period, which started off significantly at 9 years, as well as the clear and convincing evidence that Judge Belvedere found on the record of rehabilitation and of Dr. Babaknia's entitlement to resume his practice in full. And and so that's my main point, is the modest nature of it. The other point that I wanted to make was a legal point that is a response to the Department of Justice's argument in their written argument that we didn't have a chance to address in writing, which is the suggestion that Judge Belvedere exceeded her authority or her discretion, or abused her discretion by commenting on her belief of the truth of the initial charges and the incident that gave rise to the discipline in the first place. The Attorney General doesn't provide any authority for the idea that exceeded the scope of the discretion that the administrative law judge had in that setting. As the furthest they go is by commenting on some of the substance of the Hall case, which Judge Belvedere relied on as well. Hall versus Committee of Bar Examiners, 1979, 25 Cal 3rd, 730. And the Attorney General's office uses that case to make the point that ostensibly that an administrative law judge doesn't have the discretion to address the merits of the original offense. However, the case doesn't say that. On a deeper re-review of the case, the language that the Attorney General's office cites strictly depends on the legal impact of the administrative proceedings that predated the appellate proceedings that were ongoing at the time. All the Court of Appeal was saying is that it wasn't their place to make a re-ruling or even to address the finality of the original board decision. As far as the petition is concerned, we don't have a final board decision yet. That's what we're here to hopefully influence today. And so the language in the Hall decision that seems to say the Court of Appeal couldn't at that point reverse or reconsider the findings of the board doesn't apply. Nor does the Hall language limit this board decision regarding the petition in such a way that would somehow invalidate or nullify the finality of the original decision. Nobody is asking to expunge or to reverse the finding that gave rise to the discipline. That's not on the table. To the contrary, everybody understands that decision is final. It's part of the record, and Dr. Babaknia is not asking that be expunged, reversed, or otherwise changed. All we're asking is for, like I said, a modest reduction of the discipline based on the very, very full record of rehabilitation that Judge Belvedere relied on. And that's really the entirety of the point that I wanted to make today, but I do invite questions from the board on any specific point.
Thank you very much, Mr. Shepherdson. You have 15 minutes if you'd like to use them. Ms. Jacobs, you can go ahead. Thank you.
Esteemed members of the board, the relationship between a physician and a patient is inherently unbalanced. The knowledge, skills, and training required of physicians puts them in a position of power over the patient. The patient is often in a position of vulnerability due to illness, suffering, and a need to divulge deeply personal information and then subject themselves to intimate physical examination. Such vulnerability is further heightened by the patient's trust in the physician. A physician-patient relationship is built upon trust. That involves a patient being able to have a confident belief in the moral character and competence of physicians. When there is a violation of that relationship through sexual misconduct, such behavior can have a profound, enduring, and traumatic impact upon the victim and upon the public at large and the medical profession as a whole. In 1996, this board published a sexual misconduct policy statement, which states, quote, "The doctor-patient relationship is not one of equality. In seeking treatment, the patient is vulnerable. Exploitation of the patient is an abuse of power," end quote. This case is about an abuse of power by petitioner and an abuse of discretion by the administrative law judge. Here we have an abuse of power by petitioner when he used his ungloved finger to digitally penetrate the victim's vagina during an unwarranted genital exam while he asked her if it hurt when she lost her virginity. She had trusted respondent to help treat her urinary tract infection. And we also have an abuse of discretion by an ALJ in misapplying the law and making a finding essentially of innocence after petitioner admitted the allegations in a prior finalized proceeding. The patient victim is left silenced and in the dark with the proposed decision. Her voice never able to be heard as petitioner denied her the opportunity when he admitted the offense. For the ALJ to now essentially declare petitioner innocent in a hearing on a petition for early termination of probation is unreasonable, erroneous, and arbitrary, which makes it a clear abuse of discretion. Under the law, an abuse of discretion typically occurs when a court does not correctly apply the law or bases its decision on a clearly erroneous finding of material fact. An abuse of discretion is an error of judgment by a court in making a ruling that is clearly unreasonable, erroneous, or arbitrary, and is not justified by the facts nor the applicable law. Here, the ALJ abused its considerable discretion by not correctly applying the law and by also finding a clearly erroneous finding of material fact. The ALJ's clearly erroneous finding of material fact was her decision to redetermine guilt after petitioner fully admitted every allegation in the prior finalized proceeding. On page 3 of the stipulated settlement, it states that petitioner, quote, admits the truth of each and every allegation in the accusation, end quote. Yet, the proposed order states petitioner's, quote, testimony that he believes he did nothing wrong with respect to the patient at issue in the underlying accusation is found credible, end quote. Even petitioner's written argument submitted to this board acknowledges that the ALJ made findings of fact regarding the, quote, incident that gave rise to the discipline in question, end quote, page 1. It was beyond the ALJ's jurisdiction to go on a fact-finding excursion of guilt. That was a determination that had already been made in the accusation case, not in the petition for early termination of probation case. Petitioner admitted the truth of all the allegations when he signed the negotiated settlement on May 11th, 2017. The ALJ's fact-finding of guilt was a clearly erroneous abuse of discretion. In addition, the ALJ did not correctly apply the law. A petition for early termination is not a guilt determination. Guilt had already been determined, hence the probationary term. This was not a hearing on the accusation, but that is exactly what this ALJ did. She erroneously took the admitted fact of guilt and unlawfully reversed it, making an innocence determination. Such illogical conclusions are rampant in this proposed decision and order. For example, in support of this proposed order, the ALJ cited to the case Hall v. Committee of Bar Examiners for the proposition that steadfastly maintaining innocence may reinforce rather than undercut a petitioner's claim of good character. However, this case is easily distinguishable because petitioner never steadfastly maintained innocence. He admitted all the allegations in the accusation. Moreover, Hall v. Committee of Bar Examiners even recognizes the standard of review limitations when it stated that they did not redetermine Hall's guilt because, quote, that decision is now final, end quote. Our ALJ failed to understand that key principle, that she was only to decide the issue of the petition for early termination of probation and not the underlying guilt that was previously finalized by petitioner's admissions in the stipulated settlement. In addition, petitioner has not established rehabilitation sufficient to warrant reinstatement. He has not shown by clear and convincing evidence that rehabilitation efforts were successful. Going through some of the factors determining rehabilitation. First, the nature and severity of the sexual misconduct is cause for denial of the petition. Petitioner inserted an ungloved finger into the patient's vagina while asking her if it hurt when she lost her virginity, under the guise of providing medical treatment. Such an abuse of power alone weighs in favor of maintaining probation. In addition, petitioner cannot plead guilty, thereby silencing the victim, and then years later gain the benefit of a claim of innocence when the victim was never afforded the opportunity to be heard. During the hearing, petitioner stated he admitted the accusation only in order to be able to practice medicine. The evidence also shows petitioner would gain more rehabilitative efforts by remaining on probation, as the public is guaranteed to have a chaperone for female patients. The Federation of State Medical Boards, in discussing physician sexual misconduct, states, quote, as a condition of successful completion of a program for remediation, participants should be required to articulate not only why their actions were wrong, but also how they arrived at the point at which they were willing to commit them, and how they will guard against arriving at such a point again. End quote. Here, petitioner has not been able to articulate why his actions were wrong, or how we will guard against arriving there again in the future. Therefore, complainant respectfully requests this board to protect the public by rejecting the proposed decision and finding petitioner a suitable candidate for continued probation. Thank you.
Thank you very much, Ms. Jacobs. All right, you have another 5 minutes for a closing argument, counsel. Thank you.
Thank you, Your Honor. I would like to respond to Ms. Jacobs' argument that Judge Belvedere, again, exceeded her authority or abused her discretion by discussing the credibility as to the facts of the incident. Again, Hall doesn't stand for that. The Hall case doesn't stand for that proposition, and the Attorney General's office doesn't have any other authority for that. The standard for determining whether there should be relief from discipline is the fitness of the physician now, today, and whether they have shown rehabilitation and show their fitness and safety as a physician. The facts of the original incident are relevant to that. And the administrative law judge who actually heard testimony during the trial was in the best position to gauge the credibility as to the facts of the original incident, insofar as they're relevant to determining whether, sitting here today, it's necessary to have continuing probationary oversight of a physician. And the Judge Belvedere, sitting in that position, which, like I said, was the best position to gauge credibility and to gauge the totality of the circumstances, determined that under the clear and convincing evidence standard, he was fit to continue practicing without restriction. And there's no reason that she shouldn't. In fact, the reason we have an administrative law judge take live testimony in a proceeding such as this is specifically to gauge credibility and to gauge the totality of the circumstances with the best available evidence. She also took live testimony from Dr. Schaefer, his colleague, Dr. Babaknia's colleague, as well as the case reviewer, Dr. Kundu, who was so impressed and persuaded by Dr. Babaknia's rehabilitative efforts that she spoke in favor and against her economic interest, I might add, since she is being paid to act as the overseer. She was willing, even then, to support his petition for a modest shortening of his probation. So rather than abusing discretion, I think that this is a very nice example of why we give discretion to an administrative law judge to hear evidence and to make a holistic ruling as to the fitness of a physician to continue practicing without restriction.
Thank you, counsel. All right, Ms. Jacobs, you also have 5 minutes. Thank you.
This case is about an abuse of power and an abuse of discretion. The principle of fairness must apply to patient victims who are sometimes described as survivors of sexual misconduct. Those survivors must be granted fair treatment through the disciplinary process and must be afforded opportunities to seek justice for wrongful conduct committed against them. For the petitioner to gain the benefit of the bargain in a negotiated settlement and then later claim innocence and to be unlawfully declared innocent by an ALJ is inequitable. Patient victims and their rights deserve more. At the very minimum, these patient victims deserve due process and a right to be heard. Guilt was an issue outside the scope of this ALJ's jurisdiction, a material fact not even presented before her for consideration. For her to make a, quote, credibility, end quote, determination on the, quote, underlying accusation, end quote, was an offensive abuse of discretion. It was offensive to the patient victim who was denied her due process right to be heard on the underlying accusation. It was offensive to all sexual assault victims to be essentially told that they don't have a voice in these board proceedings. And that is exactly what this proposed order does. It leaves the victim silenced and in the dark. The victim was silenced when the petitioner admitted every allegation. Now, petitioner seeks to take advantage of that silence by claiming innocence. The ALJ took further advantage of the victim's silence by finding the underlying accusation to be false without ever allowing the victim to be heard. The board can restore the public trust and confidence by demonstrating swift and appropriate action in this matter. Therefore, we respectfully request the esteemed members of this board to allow the public to continue to be protected by maintaining petitioner's probation for the remainder of his contracted probationary term. Thank you.
Thank you very much, Ms. Jacobs. All right, I'm going to turn it over to the board members to see if they have any questions for the petitioner's counsel. Let me start with you on that side, Ms. Mitchell. Any questions? Dr. Heltzer? Dr.
I have
Millett?
no questions, Your Honor.
All right, Mr. Watkins?
No question.
Ms. Torres?
No questions.
And Dr. Tsai? All right, thank you very much. No questions. That then concludes the arguments in this matter. The record is closed. Case is submitted for decision, and we are off the record in this matter. The panel will be deliberating in closed session. Thank you very much.
Thank you.
And for all the public attendees, in the interest of time, we will be adjourning this session now. We'll formally adjourn after the closed session, but we will be ending the webinar for all of you at this time. Thank you very much. The full board meeting begins tomorrow morning at 9 a.m. Thank you.